नमस्कार, आदाब, सत श्री अकाल दोस्तों। स्वागत है आपका एक बार फिर से हमारे YouTube चैनल ब्रास फ्यूजन्स पर, जहां हम आपके लिए एक बार फिर से लेकर आए हैं एक नया लेसन।
Of the agent, rights of the agent, and basically in last class we were on the last point relating to the duties of agent, or what are the rights of the principal, or it was not actually the agent's rights and duties, because we were talking about the authorities of the scope of authority of an agent. So we did that. What is the authority of an agent in emergency? For that we did your section 189, and how much I can recall, we left at your point that where agent exceed authority. If somewhere the agent acts by exceeding his authority, what will be the impact of it? What will be the right available to a principal? For that, if you remember, I made reference to your section 57, section 58, and I told you the principle which has been followed in your section 227 and your section 228. It is somehow it is similar based upon the similar provision of your section 57 and 58. I'm not going to read your provision of your section 57 and 58 of your Indian Contract Act. Just want to recall one thing you must have done in your first semester, that if somewhere one of the part of the contract is legal, another part of the contract is illegal, and if it is separable, one of the part of the consideration is legal, another is illegal, and if it is separable, then according to section 57, then the part which is lawful, that will be enforceable, and the part which is unlawful, that will be void. And similar thing is here followed in your section 227, that how far the agent is going to exceed the authority given to him, or how much he has been authorized, he has exceed the scope of authority. Then in such situation, we will see that whether the act done by him by exceeding the authority is separable or not. If it is separable, so for your section 237, one agent will do two acts. Okay, for your section 227, one agent will do two acts. One act will be within authority, another act will be out of the authority. And if both of these acts are separable, then in such situation, the act which is within authority, that will be enforceable. The act which is not in authority, that will not be enforceable, that will be void. And this section 227 is complete with your section 228, that which is saying principle not bound when excess of an agent's authority is not separable. So where it is separable, it will be the portion which is within authority will be enforceable. Where it is not separable, the portion which is both of them will not be enforceable. So how much I can recall, I have already read your sections, their provisions from your Where Act for these two aspects, that is your section 227 and section 228. Is there any need to repeat? So we have already read the provision. Now let us talk about one of the very basic principles relating to the authority of agent and relationship of a principal and an agent. We every one of you, and including me, are aware about this fact that a notice to an agent is a notice to a principal. So however, we did this principle as a general principle. We talk about it so many times, but today we are going to make reference of legal provision given in your Indian Contract Act, which is supporting this principle, or which is laying down this express principle, right? So for that, you can see your section 229. Section 229 is just saying what? That effect of notice to agent, consequences of notice given to an agent. So everybody knows that when a notice is given to principal, then it will be when a notice is given to agent, it will be considered as a notice given to the principal. So read the provision from your Where Act, and it is section 229. Any notice given or information obtained by agent provided it to be given or obtained in course of the business transacted by him for the principal shall, as between the principal and the third parties, have the same legal consequences as if it had been given or obtained by the principal. Already we know this law, but right now in this bare provision which I just read from your bare act, please mark your course of business phrase. Course of business phrase. So it is just making you clear one thing, that when a principal will be bound with the information and knowledge of his agent, when such information or knowledge is obtained by the agent within the course of the business. You must have done this law in your TPA as well while doing the notice. When we were doing the notice, as it is given in your section 3 definition, we read that when a notice to an agent will be a notice to a principal, everybody knows it, and I am just giving you one example. Today is 19th September 2020. Everybody listen carefully. I am going to ask you what should be the answer. Today is 19th September 2020. You are not my agent. I am not your principal. And here is also third party involvement, right? So suppose you and the third party, means the third person, are very good friend, and your friend told you that his house is subject to a mortgage, or his house is subject to liability, right? Your friend told you his house is subject to any charge, any mortgage, any liability. At that time, you were not at all my agent, and he gave you this information on 19th September 2020. Later on, I appointed you as my agent on 20th October 2020, and I appointed you as my agent for purchasing the house of your same friend, right? Who gave you otherwise an information that his property is subject to any liability. I appointed you as my agent for purchasing the house of the same friend, and now you are going to make a contract with that friend on my behalf as my agent. Now here question which I want to ask you, the knowledge of the liability attached to the property which you obtained from your friend on 19th September, will it be amounting to a notice to principal or not? Answer me. Will it be amounted to a notice to principal or not? Should I repeat the facts or the illustration? Or you can answer me. Is it clear? Am I audible or not? Okay, then what should be the decision? Listen carefully. I am repeating it again. Suppose you are my good friend, right? And in friendship, otherwise in general, I informed you that my house is subject to a mortgage, subject to a liability, subject to a charge or whatever, or in short, my house is subject to some liability, legal liability. And I told you this fact on 19th September 2020. It means today. On that day, it means today, you are nobody's agent, right? And I just told you, I just shared with you that my house is subject to some liability. Okay. Later on, for the same house, means for my house, you have been appointed as an agent by any person. Means there is some principal. He appointed you as an agent for purchasing my house on his behalf, right? And he appointed you on 20th October 2020, right? Now we are studying one basic principle, that information to an agent will be information to principal. Notice to an agent will be a notice to principal. This is a basic principle. Now my question from you is what? That your knowledge that my house is subject to any mortgage or liability, whether it will be considered as notice to principal or not as per your section 229. Are the facts clear to you? Whether it will be considered as a notice or not? Please reply, I want to complete agency today. You are right. No, ma'am, it wasn't within the course of the business. Thank you. Thank you. Okay, you are right. You are correct. It is not within the course of business because on the date when you got the information, that is 19 September 2020, you were not my agent, or you are not agent of the principal, and you did not get that information as agent in the course of the business. It was an information, it was a prior knowledge before the formation of agency, before starting the course of the business. So it will not be. Thereafter, let us talk about the third thing. The next thing, which is again relating to the authority of agent in relation to the principal. So let us talk about liability of agents wrongful act. We have already studied that a principal will be liable or bound for the wrongful act of his agent. Based upon the same principle, based upon the same principle, I'm here explaining you another section 238. Please see your section 238. By the heading, it will be clear to you. Effect on agreement of misrepresentation or fraud by agent. So, if somewhere any agent makes any misrepresentation, makes any fraud to third person, right, during the course of his business, first of all, section 238 is making you clear or giving you principle that the principal will be bound with the act of agent. Doesn't matter then. Sorry for the interruption. There was net connectivity issue. So I just told you 238 is first of all giving you a basic principle that if an agent is doing any misrepresentation, any fraud, then the principal will be liable for that misrepresentation, liable for that fraud. But if somewhere the agent has done that misrepresentation or fraud out of the scope of authority, means out of his course of business, then principal will not be liable. Then principal will not be liable. This is what? This is your section 238. The liability for agents wrongful act. So read the provision just in a 1 minute so that we can complete the agency. And time to time I just make you aware that for purpose of agency you need to learn only the bare interpretation of your provisions given in your Indian Contract Act. So read your section 238. Misrepresentation or fraud committed by agents acting in course of their business. Again, focus on the term acting in course of their business for their principal have the same effect on agreements made by the such agents as if such misrepresentation or fraud has been made or committed by the principal. But after that there is a term but, which is giving you what? a proviso. But misrepresentation made or fraud committed by agents in matters which do not fall within the authority do not affect the principal. So if that misrepresentation, that fraud committed by the agent not within the scope of authority, not during the course of the business, then the principal will not be bound with it. Now, let me give you example, very simple example of misrepresentation or fraud. Okay, in your first semester while doing your contract law, you must have studied that there can be puffing up, statements. And similarly, in contest, in same contest, I'm giving you an example. Suppose I appointed you as my agent for selling my certain goods, right? And while selling my goods, you made somewhat exaggerated statement about my good. Suppose you are selling a pen on my behalf, and you are saying this pen is this or that. You will get, you will pass any exam by using this pen. You made certain exaggerating statements. So you are doing any misrepresentation, you are doing any fraud, then in such situation I will be bound because you did it during the course of business and within your scope of authority that you are here selling the property. Now if you follow some wrongful act, you follow some wrongful way for selling my property, then as a principal definitely I am bound with it. But if it is not within the scope, if it is not for the purpose of the contract, then principal will not be liable for it. This is your law relating to what misrepresentation or section 238. Thereafter, let us talk about another provision. But before that, I just want to tell you, your section 238 of your Indian Contract Act is based upon the similar concept which is there in your tort, which is dealing with the master and a servant relationship and which is providing you doctrine of vicarious liability, that when a master will be liable for the act of his servant, when there will be vicarious liability of a master. So same thing is applicable. So section 238 is here giving you the same principle, same law, same doctrine which is there in your tort for an action, that is vicarious liability, that when a master will be liable for the wrongful act of his agent or when he acts out of his authority. So similarly, when we are talking about the vicarious liability, there is another tort principle which is applicable to the relationship of the agent and the principal. And what is that principle? That principle is respondent superior. You must have read this in your tort, respondent superior. Can you tell me what do you understand by respondent superior? Any one of you? Respondent superior. You did in your tort. Any idea about it? Respondent superior, what is the meaning of respondent superior?
It means man party is responsible for the acts of its agent.
Thank you, Vivek. In a very simple term, it means what? It is let the superior be liable. Hello? Am I audible? Okay. Let the superior be liable. Similar rule will be applicable in case of the principal and agent. If agent, on what principle it is based? First of all, vicarious. Your section 238 is based upon vicarious liability, and second is your let the superior be liable. So with this, we have talked about the scope or the extent of the authority of an agent in relationship to, in regard of the relationship of a principal and the agent. Now we are talking about something very important, a very important topic relating to the principal and agent, that is what right and duties of an undisclosed principal. So at times it may be possible that when an agent is going to make a contract, he is not disclosing the fact that he is agent and he is acting on behalf of the principal. So there are the three possible circumstances in any contract relating to the principal and agent, and what can be one possible circumstances that where the agent disclosed the name of the principal as well as he disclosed that I'm acting on his behalf. So first thing that he explained, he disclosed that he is acting in a representation character and he is acting for so and so person. Second possible thing is what? That he disclosed that I am here acting in the representative authority, but he did not disclose the name of the principal. Third situation which may be there, that I am acting as an agent. He did not disclose that I am acting as an agent, as well as he did not disclose the identity of the principal. So here there can be situation that agent entered into contract without disclosing the fact of his agency, without disclosing the name of the principal, and for which we are now going to study the topic, the liability duties of an undisclosed principal. So first of all, I believe that it is clear to you who will be unnamed principal or who will be undisclosed principal. Undisclosed principal is such principal about whom the agent do not disclose to the third party. Then in such situation, what will be the rights and duties of the principal who is undisclosed? For that, please see your section 231. Section 231 in your Dare Act. Section 231. Rights of parties to a contract made by an agent not disclosed. So not disclosed, what he has not disclosed? The principal, the existence of the principal. So if agent, I'm reading the bare provision only, read it and we will do the interpretation. If an agent makes a contract with a person who neither knows or nor has reason to suspect that he is an agent, his principal may require the performance of contract. So read till here, his principal may require the performance of contract, but the other contracting party has as against the principal the same rights as he would have had as against the agent if the agent had been principal. So it is just further explanation, extended explanation of your privity of contract. First of all, in your Indian Contract Act, we used to follow the principle of privity of contract, that only the parties to contract can file a suit or can get enforcement of a contract. But at same time, when we are talking about special kind of the contract which is involving principal, agent and the third party, however the principal do not enter into the contract with third party himself, but even though because of the agency law he is able to file the suit or he is able to make liable the third party for a contract which actually entered by the agent on his behalf. तो पहला एक्सेप्शन तो हो गया प्रिविटी ऑफ कॉन्ट्रैक्ट के लिए एजेंसी, एंड फर्दर itself in agency it is here going to explain you section 231 is going to explain you the law relating to agency. It is saying that if somewhere the agent do not disclose the name of the principal or his representative character, and nowhere there is any clue to the third party to understand or to know that he is just an agent, he is taking him, it means third party is taking the agent as the principal itself, then what will be the situation, how the rights and liabilities will be governed. So first thing, section 231 is making you clear that the principal who is undisclosed is no doubt will be entitled to enforce the contract against the third party. It is his discretion, because term which has been used in the provision, that is may, but at same time it is providing a protection to the third party, that where the third party was having no idea that the person with whom he entered into contract is just an agent, then in such situation third party will have all rights, all liabilities, all claims against the agent as if he is a principal. So in section 231 is protecting the right of both original principal, undisclosed principal and the third party's right. Is it clear or should I repeat? Is this clear or should I repeat? Tell me. Clear? Okay. Is it clear or not?
दोस्तों, अगर आपको आज का लेसन पसंद आया हो तो वीडियो को लाइक करें। इसी के साथ अगर आपने अभी तक हमारा चैनल सब्सक्राइब नहीं किया है तो सब्सक्राइब के बटन पर क्लिक करिए और बेल आइकन दबाना ना भूलें, ताकि आपको एजुकेशन से रिलेटेड नए नए अपडेट्स मिलते रहें। और अधिक जानकारी पाने के लिए आप हमारे फेसबुक और इंस्टाग्राम पेज से भी जुड़ सकते हैं, जिसका लिंक डिस्क्रिप्शन बॉक्स में दिया गया है। धन्यवाद।